السلام عليكم ورحمة الله وبركاته.
عليكم السلام.
وعليكم السلام ورحمة الله.
طيب إن شاء الله نبدأ اليوم السيشن الثاني second session. ننتظر بس wait for 1 minute until everyone is joining. So I think you can see my screen.
Yes.
Excellent. Good. طيب الحمد لله والصلاة والسلام على رسول الله. Today we'll discuss clause 21 which titled disputes and arbitration. As we saw last time, we discussed the claims and the procedure for claim. We talked about engineer consultation for trying to seek or to reach agreement, and the deadline for this was 42 days. And then if no agreement is reached after this consultation, the engineer has another 42 days to give what's called determination. Okay. And just a question until everyone is joining. When or what if the engineer didn't give a determination after the whole duration or period, which is 84 days? This is considered what? Approval for the claim or no objection for, or rejection?
Rejection.
Okay, any other thoughts or any other opinion on this? Yes, it is considered or deemed rejection. Okay, and if it's deemed rejection and if any of the parties, the contractor or the employer, is not satisfied with this rejection, what they can do?
He will raise it to be dispute.
How he or the party can raise it to be a dispute? By doing what? Sending what?
By sending a letter for non-dissatisfaction letter.
Okay, so the unhappy party can escalate the issue before the deadline, which is 28 days from the engineer's determination, by sending what's called NOD, notice of dissatisfaction. What else the unhappy party or the party who need to escalate it need to do besides NOD? The party needs to refer the matter to the DAAB within 42 days from the NOD, the time of sending or the date of sending this NOD. Okay. So starting from this, if there is a dispute.
Sorry, again this.
Okay. Have you attended our previous lecture?
Yes.
Excellent. Okay. So we mentioned that there may be a dispute. Okay. Sorry, a claim. So one of the parties sent a claim to the engineer. Okay. So the engineer work in two phases, or because FIDIC needs avoidance first. Okay, because prevention is better than curing. So what the engineer have to do? The engineer have 42 days to make consultation between the two parties, trying to reach an agreement. If parties agreed, the engineer issue a notice of agreement and it is in writing and they sign it and خلاص, they agree that the claim worth whatever. Okay, or we can extend the contract by whatsoever days. So we make this agreement in writing. Okay, but if there is no agreement reached within the 42 days, the engineer will do what's called determination, اللي احنا قلناها بالعربي هنسميها تحديد أو بت, to avoid confusing it with the other term which is decision as decision is made by the DAAB. So the engineer make determination. تمام؟ بت أو تحديد. If the engineer, or so we have many scenarios. Either the engineer didn't issue anything, so we call this deemed rejection, or the engineer reject, or the engineer approves the claim as is, or he give another determination, like the contractor we mentioned. Contractor is asking for 2 million, and the engineer determination is 900,000, for example. Okay. Now, if neither party or no one of the parties send NOD within 28 days, no NOD sent. No, there is no NOD in place. Okay, what will happen? This determination, which is from the first place, is binding but not final. We call it interim binding. It will automatically have another if before this binding. It will be final and binding if no NOD served or sent within 28 days. So far, it's clear? Okay. So now, if one of the parties, contractor, is not happy with this 900,000, or the employer is not happy with this determination, and they need to prevent the finality of this determination. Otherwise, if they didn't send NOD, it will be final and binding. So to stop this finality, they need to do, first thing is to send NOD within 28 days from the engineer determination. Okay. Second thing, they need to refer the matter to the DAB or the DAAB. This referral need to take place within 42 days from the served NOD. Okay, so is this answer your question? This is what exactly we discussed the last time in our first session. Okay.
This according to 2017 or
In 17,
19?
yes. I'm talking
Yes.
about 17, yes. We are talking about FIDIC 17. Okay. Type. Now, when the matter is escalated to the DAB, we call the matter in this case, or this event in this case, or this claim, have been or became, from this point, the claim becomes a dispute. Okay, when the matter referred to the DAB, okay, and DAB dealing with it formally, now it is no longer a claim, it is a dispute. So today, what we will discuss, today we'll understand FIDIC 2017 Dispute Resolution Framework, which is the new clause, which is 21. Do you remember in 1999, how many clauses were in the three rainbow sweet box, the red, yellow, and silver? How many clauses were there?
Yes, 20.
20. FIDIC 2017 added another clause for dispute. This dispute mechanism were embedded before in clause 20. So clause 20 was dealing with both claims and its dispute in the same clause in the old version, the revision 1 or version 1 of the 1999 of the Rainbow Suite, okay, which is, and this clause 20 was for contractors claim only. Okay, we mentioned that in 2017, the claim mechanism now applies on both the contractor and the employer. Okay, and FIDIC make a separate standalone clause for dispute, which is clause 21. So once the matter referred to the DAAB, it is no longer a claim. Now we entered into another phase. We're in another process called this process is dispute resolution framework. Okay, so we need to understand how FIDIC deals with dispute. Okay, we need also to distinguish between the avoidance part of the DAAB and the old DAB. The new one is called Dispute Avoidance and Adjudication Board. The old one missed, or the before FIDIC doesn't have avoidance part for the DAB. In 2017, they added another route, which is the, I can say it, informal route for avoidance by this extra A. Okay? So we need to understand the difference between DAAB and the old DAB, DAB, without avoidance. Also, we need to understand the difference between the standing DAB and the ad hoc DAB. Standing exists from the first place, from the inception of the project, okay, with the start of the project. We'll see that as per the default timeline, parties need to have DAB in place within 28 days from the letter of acceptance or signing the contract if we are talking about Silverbook. The ad hoc, on the other hand, is an ad hoc. It's an ad hoc nature, means when we need it, when there is a problem, we can constitute or we can form a DAB or a DAB. Now, in 2017, all three books, red, yellow, and silver, DAB is standing. There is no ad hoc. Okay, and they are all DAAB, Dispute Avoidance and Adjudication Board, which means the board has a dual function, two routes for dealing with issues, as we'll see. So we need to understand this and distinguish between the standing versus ad hoc, the DAAB versus the old DAB without avoidance. Okay, we need to know the procedure for avoidance and the procedure for a formal adjudication. Okay, and we need to understand why FIDIC made this as a best practice. And the FIDIC philosophy is always they need to try to solve issues or problems or claims at the lowest level and least cost level and without escalating it. Hoping for this. So the new clause, which is clause 21, titled Disputes and Arbitration. Okay, allow me to ask you a question. If there is a claim, and this claim the engineer dealt with, and he made a consultation, but no agreement was reached, and then the engineer made a determination, okay, assuming same example, the engineer dealt with a claim for example, a contractor submitted extension of time for 70 days. Okay. No agreement during consultation. Then in the second 42 days, the engineer, after doing his due diligence, and the engineer, when he work as per clause 3.7, is he deemed to work for the employer or he need to be neutral and give fair determination?
Neutral.
Neutral, excellent. Okay, so the engineer worked as per clause 3.7, and his determination is that the contractor is entitled to, he can give the contractor extension of time for 10 days instead of 70 days. Okay. My question is, based on this determination, can we consider this situation we reach the dispute or not?
unless the contractor he send the notification for this agreement, we cannot telling it's dispute.
Yes, exactly. So without having NOD
MOD,
then-
yes.
and then referral within 42 days from the NOD to the DAB, it is not a dispute because maybe the contractor
I will accept.
maybe the contractor is try to exaggerate his claim and he knows he deserves maybe 10 or 12 days and everyone didn't comment on it, so it doesn't mean the determination is different or doesn't align with the claim. There is a dispute happened when there is NOD, notice of dissatisfaction. What is the deadline? The default number of days for sending this notice is 28 days.
28 days.
Yeah, and referring the matter to the DAB within 42 days. Without both steps, no dispute. خلاص? And if nobody send this notice, after 28 days, it will be only final determination or final and binding. Sorry, only binding or final and binding, not only binding or interim binding. It will be final and binding. Okay? تمام. So we assume that no, in this case, the contractor sent an NOD and he referred the matter to the arbitration. So now we have escalation from a claim to a dispute. How FIDIC is dealing with dispute? How can we? What is the composition of the DAB? What is the difference between the DAAB and the old one, the DAB? What is the dual role? All this we'll discuss until we see if the dispute reached arbitration and so on. Okay. طيب. So we have 8 sub-clauses starting with the constitution of the DAB. ازاي هنكون ال DAAB. Okay, and what if we failed, the parties failed to appoint the DAB member? What is the mechanism in the FIDIC? And then what is the avoidance procedure? The first A of the DAAB. Okay, how can parties seek non-formal advice from the DAAB? What is the avoidance rule? It will be discussed here in subclause 21.3. Then, if one of the parties need to escalate a matter and get a formal adjudication decision, this clause 21.4 will deal with how can parties obtain DAAB's decision, which is formal and binding. Okay. As a multi-tiered procedure for dealing with disputes, okay, before going to arbitration, FIDIC recommends that the parties need to cool down and to get like a pause or stoppage period, trying to attempt to reach amicable settlement. So either they reached amicable settlement or not, they try to attempt. So there is no direct referral to arbitration after the decisions. They need to stop. There will be like a pause duration, which is 28 days. Okay, to attempt. It doesn't mean they will have or they will reach, but they will try. And maybe if they didn't talk to each other, they need to wait for this 28 days before referring the matter to the arbitration. If there is a decision from the DAB, formal decision, and one of the parties send again an OD, which means he need to escalate the matter to arbitration. Okay. The other scenarios is what if one of the parties failed to comply with DAB's decision? What will be the situation? Okay, we need to refer it directly to arbitration or what? And what if there is no board in place? The parties didn't or failed to form a board. What will be the situation? if there is a dispute, a claim, and one of the parties sent NOD to the engineer's determination, so they can. So do you think that FIDIC will ask them to form a DAB, or they can go directly to arbitration? We'll see in subclause 21.8. So this is our roadmap for clause 21, which deals with disputes and arbitration. Arbitration, FIDIC doesn't want to reach to this stage. FIDIC is trying to make all possible mechanism to avoid reaching this arbitration stage. Do you think why? Like the engineer start with a consultation.
Takes time and expensive.
Very
It's very expensive and takes times.
And also it affects and may destroy the relation between the parties. So in the future, it will they will have like some hostility against each other, and also it is it will be spreaded and it will harm both parties, may harm both parties' reputation. Okay, so this is why, but it is like the last resort for solution. If the engineer who is neutral when making determination or trying to seek agreement first by consultation, all these steps then at the AAB, which can give a non-formal advice, okay, and then they can give a formal decision. If all these steps were not applicable or failed or doesn't solve the problem, then the last resort is arbitration, which we're trying to avoid. Because as you exactly mentioned, it takes time, takes huge amount of money, and it will affect the relation between parties and may affect the reputation also. Okay. So the strategic role and philosophy, we will have a new board which can work in two functions. One is formal and one is informal. Okay, the dual function for the DAAB. First, the avoidance, then the other one is the adjudication. And we will have it standing from the start, default model per 2017 in all three books. The DAAB is a standing, we need to form it with from the start, okay? And then we have a tiered, multi-tiered dispute resolution mechanism. It is not, we start with engineer, agreement, then determination, then if the non-formal and advice from the DAB, then a formal from the DAB until amicable settlement and so on. They call this multi-tiered dispute resolution mechanism. Appointed as the project inception, standing, 28 days from the LOA, remains for the contract duration, okay, integrated with the project governance, okay, and the main role, or like the engineer, always is the decision are comply now, argue later, or pay now, argue later. What is the point of this compliance or payment? Then there is a mechanism for disagreement, because we are our FIDIC make the project progress and project interest as a high priority. We have a construction project and we need this project not to struggle or to be a troubled project by stopping the payment or stopping decisions or stopping cash flow. Okay. Tiered, multi-tiered, because we have engineer determination.
Question here. Sorry,
Yes.
I want to
Yeah.
ask you a question here.
Yeah, go ahead, please.
Standing up, do you think it's reduce the authority of engineer? And in the last session, 2017, because it's I think it's like reduce the authority of the engineer. I think, but I'm not exactly.
Right. there is no reduction of the engineer's authority, but let's think about it. If I am the engineer, okay, or my company is the engineer, I am the appointed engineer representative by my company, okay? I get paid by the employer, okay? The FIDIC and the clause obliged me to work neutrally, okay? However, if you know, everybody knows that at the end of the day, this company or my company is get paid by from the employer, okay? If there is no DAAB and one of the companies or the engineer try to make it easy for the employer or to work in favor of somebody, which is violation for the contract, and it is not an ethical decision. But I believe if a company or engineer try to do this, he will think twice because there is a DAB in place, a DAB, which will check and verify his determination. Okay, and also from the other side, it may be a good point for him not to upset the employer. Like the employer knows there is a DAB. If there is a problem and the contractor think that the engineer has some bias or working in favor of the employer, for sure he will escalate the matter to the DAB. And in that case, it is better for the engineer to give a fair determination and to work neutrally. But it is the same authority of the engineer or same obligation on it. There is no any contradiction yet. Okay, because DAB start after the engineer determination, unless both parties seeking informal advice, as we will see. Okay. Type 21.1, the first subclause is talking about the forming, the constitution of the DAB. How can we form the DAB? What are their purpose and role, appointment timeline, composition, selection? This clause gives us the mechanism for the establishment of the DAB. Okay. So first thing, it is standing, and we need them from the start. So the deadline is 28 days from the letter of acceptance if we are talking about thread or yellow book, or contract agreement signature if we are talking about silver book. Okay, so it is from the start. The default mechanism or the default number of DAB's members in the 2017 box is 3. Okay, however, parties can amend it and make it sole member. If it is one member, they call it sole member. The default is 3 members. If we are talking about a big project which worth billions, what do you think? Sole member is better or 3 members?
I think three is
3
better.
members. Yes, exactly. So 3 members because it gives them the opportunity to discuss, brainstorm, and their decision will be much better. Okay. So the default in the contract data, if the contract data is left blank, okay, or the DAB default number is 3 members. However, they can amend it or they can change it, or the client can change it during the pre-contract, during the procurement, and make it a sole member. 1 member, they call it sole member. Okay. And it is a standing DAB, not a ad hoc. Ad hoc means when there is a problem, we start forming them. No, as per new FIDIC 2017, parties need to establish the DAB within 28 days from the LOA, letter of acceptance. Okay, how parties will agree and form this 3 member, we will see. Okay. So this subclause decide dispute. The role of the members or one of the sole member, they will do the adjudication. They will give the decision, or if there is informal referral, they will give the advice, the avoidance advice. Okay, jointly appoint members by parties, as we will see, standing, not ad hoc, and they have dual role. Formal rule and avoidance rule. Okay. So the first one is avoidance, when parties jointly refer a matter informally to the DAB. We need your advice informally. Okay. And there is the real decision or adjudication when one of the parties refer a matter for a formal adjudication as per subclause 21.4. So they have dual role, as we'll see again. Agreement and remuneration parties, the contract between the employer and the contractor, general conditions, we are assuming it is FIDIC 2017. So the 2017 is the general conditions, and they will have for sure a contract agreement, and they will have particular conditions and so on, the other contract documents, BICs and so on. However, there is another agreement between three entities, three parties, the contractor, the employer, and the DAB members. They call it DAAB agreement. Okay, in this agreement, it will specify the duties of the DAB members, their fees, and so on. Okay. Replacement and termination will be as per the contract. If someone has, for example, some illness or there was a death of one of the member, how can they replace? All this mechanism will be detailed in this DAB agreement. Term expiry, the agreement should be until the end of the contract, okay? Or in some cases by giving a notice, effective date of discharge, it will be as per clause 14.12, okay? Or if DAB decides all referred disputes, there is no any more dispute, so the term can be expired after that by 28 days, or if the contract terminated, the main contract, which is a contract between the employer and the contractor, so no more need for a DAB. The DAB will be terminated after 28 days if the main contract or the contract between the employer and the contractor is terminated. Right. The appointment, if we are talking about the default, which is 3 member, party A, for example, the employer will elect 1 member and send the name of it to the other party for no objection or for agreement. Okay, but first in the contract, in the tender document, we will list names of potential adjudicators. Okay, Engineer Muhammad, Engineer Ali, Engineer Hussein, these are the people which we can choose from them, the adjudicators. So the first party, for example, the employer, will choose, okay, I picked Engineer Ahmed, okay, and he sent to the contractor for approval. If no objection, خلاص. Same thing, the contractor will choose a name as adjudicator and send to the employer for agreement. And then these 2 members will jointly agree on the 3rd member, which will be the chairperson. So the 3rd member will be the chairperson. Okay, the chairperson doesn't have like more power over them. All decisions need to be get by normal votes. Okay, and decision get by majority or consensus. However, for administrative purpose, they will have this person as a chairperson. He's the one who can be addressed in communication. If something addressed to him, it means that it is addressed to the entire DAAB members and so on. So a chairperson doesn't mean he will have more power or more votes, but it is just for administrative purpose only. So this, if we have 3 members. Also, FIDIC dealing with situation if people or the parties didn't agree. So the default mechanism in the contract is that there will be appointment entity, okay, which can choose the 3 members, okay, like FIDIC president. Then the default in FIDIC is the FIDIC, if the parties fail to agree on the 3 members or 1 member, they can refer the issue to FIDIC, and FIDIC president can elect this or these members. Okay. Appointment is 28 days after letter of acceptance. Okay. And choose one, either it is a sole member or 3 members. Okay, each party select one and both agreed on the chairperson as we mentioned. Who pays the fees of the DAP? The DAP's remuneration is split 50-50 between the contractor and the employer. Okay. However, who pays the engineer's fees?
The client.
The employer. Because it in clause 3, the employer shall, and shall means obligation, appoint an engineer, and he pays the engineer. However, in certain situation, the engineer need to work neutrally and as if he's deemed not working for the employer. But that from day one, it is not working for anyone. It is a pure neutral entity. Okay.
The payment is monthly or when they deal with the problems?
No, it's monthly, and this are specified in the DAAB agreements, which is not yeah. If you need to get idea about the DAB agreement or any form, let me tell you this. For any book of the 2017, when you open like red book or yellow book or silver book, you will find 3 parts on any of these books. Okay, first part is the general conditions, which we from clause 1 to clause 21. General conditions. Then part 2 is a guidance for preparing the particular conditions. Okay. The third part is some forms and template. Like if you need a template for LOA, you can find in this part. If you need to find a template for DAAB agreement, like a model, you can find in this part. Okay, so the point is DAAB agreement will exactly specify their fees, how they get it, who pay it, and the duration and so on. Okay, and what if they didn't get paid? Are they bound to give determination, or they can stop determination? All this is the DAB agreement itself. Okay. We mentioned that in 2017 it is better to have it standing, which mean, okay, imagine with me we have a 3 qualified professional engineers, persons, whoever, who are getting important report, making site visits. They are aware of the project progress and matters, claims, and so on. So if they are already aware and on board from day one, as a firefighter, where they don't have any idea about the project or the situation or what's going on on site. So from your perspective, which situation is better when this three or this sole member, if it's one member, start from the inception as a standing board is better, or the ad hoc when after the fact and after a problem happens, they came to try to solve it or to give decision about it. For sure, everyone will say the standing one where they can work proactively, not reactively. What does that mean? The three members, they can ask parties, guys, we understand there is a trend in some problems, there is whatever situation. They can ask parties to ask them for advice, for informal advice, for, okay, as a proactive action to avoid disputes. Or parties can jointly agree to, okay, we have this agreement about this, and instead of sending a claim and referring the matter and escalating the matter, let's see if we can get from these three persons, three professional, the standing there, their informal opinion. Okay, there is no doubt about their impartiality. They must, in all situations, be impartial. Even the one appointed by the employer doesn't mean he's the employer adjudication. No, no. It doesn't mean he's selected by the employer or selected by the contractor. He is the contractor's party or the contractor's adjudicator. No. It is a must for them to be impartial all times. And even in the informal advice. Okay? So by this comparison, we all agree that standing tab is better than the ad hoc instead of bringing firefighter, because these people will have all the information, they have access to sites, they have access to important information, they are copied in important correspondence, so they are aware, okay? So they can give or play the avoidance and proactive role. In case of failure to appoint, as we mentioned, there will be an entity like FIDIC, which can appoint the DAP. So always FIDIC has a plan B to prevent any stoppage and being stuck in any time. Type. If we reach a deadlock mechanism, failure to appoint the DAP, okay, what will happen? Failure to appoint is contractually defined and occur if parties fail to agree on a sole member or three members. And at the end of the day, the contractual remedy, either party may apply to the designated appointing official, which is the default is president of FIDIC. If you visited the FIDIC website, you will find a list called presidential list for adjudicator. Anyone who is certified FIDIC adjudicator is mentioned in this list. So the president can select based on the experience, skills, and project also familiarity or region familiarity, one of these people to work as adjudicator if parties didn't fail to agree on them. And the outcome will be final as per the contract. Now we have a DAAB in place. Okay, good. When we will have a DAAB in place, DAAB exists when the DAAB agreement is signed. So the contractor and the employer and the contract have a contract. Employer, contractor signed a contract, which is FIDIC 2017, for example. And they signed another agreement called DAAB agreement from three entities, the contractor, the employer, and the DAB member. One side signed this agreement, the DAAB agreement. In this point only, we have a DAAB in place. This is a good news if we have a DAB in place, so we can work with them in two routes. First one, which dispute avoidance, as per clause 21.3, subclause 21.3, we can refer to them informal, ask them for informal advice as a part of collaboration. This informal advice will be binding? No, it will be non-binding. Okay, but it will help parties to avoid disputes. like contractor and employer, having like a debate or discussion about this scope is with us as a contractor or it is not part of our scope. And there is discussions and the letters and so on. So one of the parties or two parties agreed, okay, let's seek informal advice from the DAAB's member. Okay, instead of hiring or asking third party who's has nothing to do with the project and have no idea about the project. These people are there and they are has familiarity and they know the project well. So we can seek informal advice. What is the conditions? What is يعني ايه المطلوب او what is ايه الشروط عشان نطلب منهم informal? And it needs to be joint request, which mean from both parties, the employer and the contractor. المقاول وصاحب العمل ممكن يتقدموا بطلب نصيحة غير ملزمة من الأطراف البورد بتاع الادجوديكيشن اللي هي لجنة تجنب وفض النزاعات. Okay, it's called informal non-binding advice. طيب, what is the other way? The other way, which is the formal adjudication. What is required is one party send NOD to engineer's determination and escalate and refer the matter to the DAB. In this situation, it is a formal referral, so it will be a formal procedure and the decision will be binding. Okay, we agree that the engineer give determination. The DAB in the formal or the formal route, they give decision, قرار. Engineer determination, سميها تحديد أو بت. Okay, to differentiate between the DAB's decision and the engineer determination. Both are binding. The engineer determination is binding. Also, DAB decision, formal decision, is also binding. Okay, is it final or interim? Same thing. If one of the parties sent NOD within 28 days from the decision, it will not be final, but it's still binding until arbitration or amicable settlement parties agrees on it, on otherwise decision or any other agreement. So avoidance happens when informal assistance jointly requested by the parties. Okay, the contractor and the employer ask the DAB's member, please, we need your informal advice on this situation. If that scope, for example, within the contractor's scope or it is out of the contractor's scope, is the contractor is entitled for this? What do you think? And so on. What is the purpose? Is avoidance, proactive to work type. Again, to just make sure we are all on the same page. When parties jointly refer a matter or any issue to the DAB for assistance, okay? The board advice will be binding or non-binding in this situation?
Non-binding.
Non-binding, exactly. Type. On the other hand, one party's which we'll see in 21.4 here. So here 21.3 is non-binding. It needs to be jointly, just for assistance and for avoidance. And if we need to escalate, we need to go to what is the mechanism of 21.4, which is a binding decision. There is NOD in place. Within how many days? Same, like the NOD on the engineer. It's same, the NOD on the engineer is 28 days. We need to refer the matter to the DAB within 42 days. And this referral, we get
Question,
a
please.
decision.
For the 42 days, the
Yeah.
cutoff date, it is after NOD or from the
Yeah,
start
after
when
NOD.
when?
Yeah, after the NOD, we have 42 days to send to make the referral to the DAB after the NOD. Okay. Type. In this case, as per 21.4.3, DAB's decision here will be binding or non-binding?
21.4 binding.
Binding. Okay, so the DAB decision here, because it is what? It is a formal referral from one party who's not satisfied with the engineer determination, for example. Okay, so this is the dual rule of the DAAB. The first one is for avoidance, which is 21.3. We can get informal advice type. Can we minute and record this informal advice and use it in 21.4 and tell the adjudicator, do you remember when we asked you for advice and non-binding and non-formal advice, you mentioned blah, 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 and use it as an evidence in 21.4 or maybe later in arbitration?
I think no.
Yes, maybe use.
Type. What do you think? What is the better? To make it without prejudice like informal, تمام؟ يعني مع الاحتفاظ بالحقوق without prejudice, or we can use it. طيب. I will answer this. It is, as some of you already mentioned, it can't be used in the future, or we call it contractually non-admissible event, or we call it the decision or the advice, not decision, the advice as per 21.3 is without prejudice, which means you can't use it in the future as an evidence. So what is the point? Why FIDIC make this without prejudice? If we need to seek informal and to work in a good faith to prevent any problem and to have to speak openly and without being afraid of this will be minuted or used against parties. So in informal advice, FIDIC mentioned it can't be used in the future, which contractual or legally they use terminology without prejudice. So if you are arbitrator or if you are adjudicator and you get an evidence or a minutes of meeting or anything and it is mentioned on it, it is without prejudice, it means it is non-admissible event. You can't use it. Okay, it was created or provided under this without prejudice concept. I'll give you an example. I worked during my working in with a big developer in Qatar. Okay, or it's a big actually organization. We had a dispute with one of the companies in a certain terminal, in a certain airport, okay, not in Qatar, but outside Qatar. And the dispute mechanism in this contract, it was a GCT contract, and the dispute mechanism was if there's a problem, they can go to adjudication, but it's a different adjudication from FIDIC adjudication process. Okay, so the point is when we try to make like a negotiation with this contractor after he referred the matter to the adjudicator and we get a notice from the adjudicator, we at like 7 p.m. we received an email that I am the adjudicator and the XYZ contractor is referring this matter because you didn't pay him whatever invoice. المهم, at the end of the day, one of the strategy was to make like negotiation with this contractor. So we got advice from our legal department. Okay, so we have like a legal firm and meeting with them. The first advice to us to me and the vice president is when you start your negotiation and meeting, you need to mention this. This meeting is without prejudice. You can't use the minutes of meeting or what we mention in this meeting in whatsoever future escalation. Okay. So this is so the bottom line is whatever non-binding or whatever assistant or whatever advice taken in non-formal way from the DAB is without prejudice, which means we can't use it in the future as an evidence. Is that clear?
Clear, and
And
this
this
is
is
good
better
to solve
solve. Yeah, exactly. Everyone is talking openly without any problems. There is no any bad faith. ما فيش حد بيتصيد لحد كلام ولا شيء، بحيث ان الاطراف تحاول توصل لحل ودي. تمام. This is what's mean without prejudice. ما تبقاش فخ، يعني انا رايح اسال الدي اي بي عشان امن نفسي لما اجي اقدم يعني ريفير ماتر in a formal way. تمام. طيب لسه معانا 5 دقايق before البريك. في اي اسئله so far؟ شباب في اي اسئله so far على الجزء اللي احنا اتكلمنا فيه؟ احنا توقفنا عند 21.4 clause. طيب
Regarding the neutral nature of DAB, ad hoc, maybe ad hoc DAB is more neutral than standing. Is it true?
طيب هو neutrality او عشان avoid any dispute or any conflict ما يكونش في طرف هو اللي بيدفع الفيز او الاتعاب بتاعتهم. تمام. يعني in both cases the remuneration او الفيز بتاعت الداب paid jointly split it 50-50 by the contractor and the employer. فما فيش حد ايه يعني رزقته عند واحد من الاثنين، ولا كسر عين التاني، ولا هو اتعابه عنده، ولا خايف على لقمة عيشه عنده. فالبوث are neutral and both are يعني impartial. ليه؟ لأن الأتعاب بتيجي سبليتد 50-50، لا هو واخد أتعابه من الإمبلوير فقط ولا أتعابه من الإنجينير فقط. ولكن الميزة بتاعت الستاندنج they are aware, they have all the info from day one about the site, the situation, the parties, and يعني even they can يعني يدعوا البارتيز ان هم يطلبوا يعطوهم النصيحة اللي هي الغير ملزمة دي. لو يعني وجدوا في يوم من الايام ان في اسكاليشن ممكن او مشكله ممكن تحصل، فممكن يقولوا ايه رايكم تتقدموا لنا انتوا الاثنين بطلب كده جوينتلي ان انتوا يعني تطلبوا non binding and non formal advice. تمام. important correspondence they are copied. They have to visit the site in some regular basis so they are aware of what's going on. الداب الاد هوك داب زي اي حد كده، تخيل يبقى عندك بايلز اوف دوكيومنتس. بعض البارتيز ممكن يبقى شاطر في الريكوردينج، التاني مثلا بيشتغل كونتراكتور ما عندوش تيم ان هو يدوكيمنت all the notices, all the instructions, all the whatever events. So maybe it is يعني one party will have some privilege if it is not a standing dab, and they can convince the ad hoc dab with his point, because at the end of the day they have nothing except the document which will be submitted to them. Okay, and also takes time for them to be aware of all the history of the project. So this is why FIDIC prefers the standing dab, and all are paid from both party in a splitted way, 50-50. So they are all there is no conflict of interest or possibility of any bias from them. اوكي يا شباب.
Thank you.
طيب اتفضل.
Good. Thank you.
welcome. طيب now I believe it is almost 8, so we can take 10 minutes is okay for you as a break. طيب خلاص يبقى ان شاء الله. نعم.
Suitable, yes.
اوكي طيب خلاص. 8:10 inshallah we'll resume and see you inshallah. Assalamu alaikum. السلام عليكم ورحمة الله وبركاته.
عليكم السلام ورحمة الله وبركاته.
طيب inshallah we'll resume. We talked about the DAB, the formation, the role, and the dual role. For as per 21.2, we have first 21.1. Let's start from the beginning to see our roadmap here. Yes. اتكلمنا على 21.1 constitution of the DAB, formation of the DAB, and if parties didn't or failed to appoint, how can they appoint it? And then the dual role, the first one, which is avoidance, which is non-binding and informal, and the real decision where one of the parties refer a dispute after NOD to engineer determination to the DAB, and in this case, the DAAB will give a formal and binding decision. Okay, so we reached subclause 21.4. So there is a dispute, and this dispute referred formally to the DAB, and at the end of the day, the DAB gave a decision. Okay, what if this decision was not fine, or one of the parties is not happy with this decision? What they can do to stop the finality of this decision? Same like in case of the engineer determination, the unhappy party needs to send what's called NOD, notice of dissatisfaction. But before that, we mentioned that we need the dispute to be referred, NOD to be sent. And in some cases, the referral to DAB can be done directly in certain situations, like in case of non-payment or contractor doesn't receive financing charge on some delayed payment, or disagreement over parties' entitlement for termination. In these three situations, in these three cases, it is exception for referring a dispute to the DAB directly without need for NOD. Okay. Type. Now, if one of the party is not happy with the DAB decision, so similar to the engineer determination, here, if one of the parties is not happy with or we call it dissatisfied with the decision, the party needs to send NOD. Okay. Dissatisfied party may give notice of dissatisfaction to the other party, copying the engineer and the DAB. NOD must state what exactly they disagree, because sometimes the claim is constitute, or the decision constitute many items like money, time, part A, part 2, and so on. So maybe the contractor or the employer may disagree with a specific part of the decision, not the entire decision. So they need to mention what exactly they are not happy with. NOD must set out dispute matter or reason for the dissatisfaction, what exactly and what is the reason they are not satisfied with this decision, because of what. Timeline, again, it is 28 days. Otherwise, this decision will be what? Will be final and binding. So it can't be escalated. people or parties can't go to arbitration without NOD to the decision. As we mentioned, we have a multi-tiered, so we can't go to the we can't escalate from a certain tier to the other tier unless we are following the FIDIC mechanism. And in some cases, if there is no DAB in place or some parties doesn't comply with the decision, we'll see if they can go directly to the arbitration. Okay. If there is a partial dissatisfaction in a certain part of the decision, the party who sent NOD need to specify what exactly they are not satisfied with. Now, one of the parties sent NOD to ADAP's formal decision, which means decision is not final and this party can escalate it to the arbitration. But FIDIC mentioned that there should be like a pause duration, stoppage duration for attempt. Attempt doesn't mean will achieve, but we will try to attempt amicable settlement. تمام؟ حل ودي after NOD before going to arbitration. Another trial or another effort from FIDIC to avoid arbitration, which, as you mentioned, it is costly and it takes some times. Because at the end of the day, even 48 days يعني considered like 1 month, but still it is not a 3 months or 6 months or 1 year. At the end of the day, the TAB give us a decision in a 48 days, which is a good يعني duration. Okay, not so long compared to arbitration or litigation. طيب. The amicable period in 2017 is 28 days after NOD given, which means after NOD, parties can't go directly to arbitration. They need to stop for 28 days. Either they talk to each other, either they try to make amicable settlement or what, but they need to cool down. Maybe during this stoppage, some wise people or executives from both parties or can talk to each other and solve the matter without escalating to arbitration. After the 28 days passed, arbitration may commence after the 28 days. Even if they didn't talk to each other or any attempt was made for amicable settlement. يبقى العبرة هنا ان احنا بدل ما هنروح directly to the arbitration لازم كده فترة توقف الناس تهدى cooling down for 28 days. لعل وعسى يحصل هو amicable settlement. After 28 days, parties can refer, any of them can refer the matter to the arbitration. تمام. Method, direct negotiation for amicable settlement, mediation, executive, expert, whatsoever. طيب هسأل سؤال، هل ممكن الناس تستعين بالداب إن هم يوصلوا معاهم لحل for amicable settlement؟ What do you think؟ يعني أحسن ال NOD
I think
ده كان dissatisfaction على DAB's decision. طب ممكن بعد الديساتسفاكشن على DAB's decision ده أجيب الداب برضو تاني أقول لهم تعالوا والله ساعدونا على الحل الاميكابل؟ إيه رأيك يا باشمهندس صادق؟
إن في طالما في حل.
طيب هو دي سبيسيفيك كيس الفيديك بيرجح او يعني بيريكومند نو DAB should not conduct amicable settlement. الداب في حاجتين كده ما يعملوهمش، تمام، عشان برضو نحفظ الانتجريتي بتاعتهم ويبقى ليهم برضو الاستقلاليه وكده. منهم الفيديك بيريكومند لا we can't use or we shouldn't conduct amicable settlement procedure مع الداب. ليه؟ لان اصلا الديساتسفاكشن جه على قرار للداب، فالداب ما تجيش تناقض نفسها او تيجي تحل الموضوع، فاصبح ان هم كده زي ايه يعني لا مش ما ينفعش ان هم take part in the amicable settlement. دي واحده. الحاجه الثانيه during arbitration they can't be a witness. الاربيتريتور ما يقدرش كده يجيب الايه والله يقول فين الداب ده تعالى انت خدت القرار ده ولا بتاع وايه ويبقى ويتنس. دول حاجتين كده يونيك للدابز ممبر. don't use them in amicable settlement even in the start before escalation زي ما اتفقنا كان في طريق اللي هو البرو-اكتيف اللي هو بتاع الادفايس نون بايندينج ادفايس، ثم البايندينج ديسيجن during النون بايندينج اللي هي 21.3. احنا ممكن نستعين بيهم كده amicably or informally for informal advice. بس بعد 21.4 بعد الديسيجن نفسه لا خلاص ما ينفعش استخدمهم في الاميكابل سيتلمنت ولا في الاربيتريشن. الاربيتريتور يجيبهم از ا ويتنس، يسمع كده كلامهم كشهود يعني. تمام، ده الفيديك بيريكومند الكلام ده يعني. اوكي، بوست ديسيجن اربيتريشن ده بقى اللي هو الفاينل ريزولوشن، دي اللاست تير عندنا في الديسبيوت، لان ما يعني الفيديك بيرجح الاربيتريشن از لاست ريزورت مش المحاكم العاديه او الليتيجيشن يعني. تمام، فاللي حصل ان احنا بعد ما حصل ان او دي على القرار بتاع الداب الديسيجن، وتوقفنا كام يوم في الاميكابل سيتلمنت؟ 28 يوم للاميكابل سيتلمنت. either parties try to achieve agreement or not or settlement or not. دلوقتي نقدر ان احنا نصعد or any parties can escalate the matter to arbitration. Arbitrator's power or tribunal power ليهم ان هم open up و review decisions و non-final DABS decisions and so on. طيب what if لو ما كانش عندنا DAB in place وحصل dissatisfaction على engineer determination؟ في الحالة دي we can refer the matter directly to arbitration. يبقى مش هنروح نشكل الداب متأخر، لا، في 2017 with the mechanism of agreeing on the composition or the forming of the DAB، وبعدين حطوا كمان entity في حالة ان احنا اختلفنا زي الفيديك president as a default. لو ما تشكلتش وحصل مشكلة، لا ما اقولش بقى ايه انا اروح اتفق على الداب تاني، لانهم مش هيتفقوا اساسا، كانوا اتفقوا عليها من زمان. ففي الحالة دي الفيديك بيقول ان انت you can go directly to arbitration لو ما كانش فيه داب in place، ومش محتاج ان انت تقعد الايه الاميكابل سيتلمنت اللي هي 28 يوم دي. اوكي، ده بالنسبة للاربيتريشن. final settlement ده last resort for dispute not amicable settlement or not final binding decision achieved. تمام، الرولز بتاعت طبعا الاربيتريشن بيبقى فيه 3 حاجات مهمة: السيت اوف arbitration، اللانجوج اوف arbitration and the rules of arbitration. ده كله بيبقى في الكلوز بتاعت الاربيتريشن نفسها. فطبعا الديفولت عندنا الانجليش، والديفولت في اللو اللي هو اللو بتاع البلد، لو ما اتذكرش يبقى البلد اللي بيتنفذ فيها المشروع. والرولز الديفولت اللي هي الاي سي سي رولز. طبعا البارتيز كانت تشينج اول ذيس in the particular conditions. ده كده الديفولت بتاع الفيديك يعني. نفس الشيء ممكن يبقى 1 arbitrator او 3 appointed under the ICC rules. الرولينج لانجوج هي ال of contract unless agreed otherwise، ده برضو الديفولت. والarbitrator power full power to review revise the decisions non-finding non-final. أي شيء final ما we can't open in the arbitration. يعني لو في عندنا determination لم يرسل عليه أو ما فيش party sent any NOD عليه، فأصبح determination ده final. The question is can we challenge this final binding engineer determination on arbitration؟ يعني arbitration بقى كده نعمل فيها اي حاجه حتى لو قرار كان فاينل؟
No.
لا، اي فاينل decision or determination خلاص خلص. we can't challenge in the arbitration. تمام، الانجينير طلع determination ومفيش ان او دي اتبعتت خلال 28 يوم، ده خلص كده طول العمر، خلاص ده ما فيش. تمام، الاربيتريتور حتى لو حصل اسكاليشن ليها from their jurisdiction هيستادي الماتر، هيلاقي ان القرار ده فاينل، فما يقدرش يقرب منه، هيقول ان القرار ده فاينل. ما ينفعش ان احنا ايه نعيد الانتايتلمنت ندرسه وندور فيه ولا اي حاجه. بل بالعكس البارتي اللي هو صاحب الحق ده ممكن ياخد منهم، يروح للاربيتريشن عشان ياخد منهم بس ايه لو البارتي التاني is not complying ياخد منهم بس كده enforceable decision او enforceable award. تمام، عشان الانفورسابيلتي في المحاكم وكده. انما الفاينل determination او final decision is a final، ما ينفعش يحصل له escalation or ان هو يتراجع from entitlement perspective في الاربيتريشن. arbitrator power full power، عشان كده ايه في النون فاينل. اوكي، نون فاينل اونلي، الفاينل لا ما يجوش ناحيتها. تمام. طب الانجينير او الانجينير ريب ممكن يستدعوه كويتنس؟ يس. الادجيديكيتور نو. تمام. ده decision admissible ممكن تستخدم as evidence؟ يس. طيب لو كان الداب advice as per 21.3 is admissible في الاربيتريشن؟
No.
نو، لانها ايه without prejudice. تمام، مع الاحتفاظ بالحقوق. الكومنسمنت before or after work ممكن يبقى الشغل شغال او بعد ما المشروع يخلص، مفيش وقت، مفيش مشكله. award payment is immediately due and payable. تمام، مش محتاجين بقى certification ولا اي شيء. ده كده الجزء بتاع التصعيد بتاع التحكيم او الاربيتريشن. طيب failure to comply with DAB's decision، لو الداب طلعت قرار والقرار ده ما التزمش بيه either party. if party fails to comply with a binding، سواء كان binding أو final و binding، other party can refers الفيلير ده للإيه؟ direct to arbitration. هل محتاج يستنى 28 يوم for amicable settlement؟ لا. تمام. وبالتالي الموضوع بتاع الاميكابل settlement don't apply، او ان هو يبعت مثلا ان او دي والقصص دي، لا مش محتاجه الريفيرال والان او دي، لانه اوريدي في قرار، والقرار ده حصل عليه فيلير اللي هو either كان binding only or final and binding. Arbitral tribunal uses summary و expedited procedure، وبالتالي عشان بس يبقى ايه الموضوع يحصل له enforceability، مش هيراجعوا الموضوع والانتايتلمنت ويسمعوا شهود، لان الموضوع خلصان. non compliance with a binding decision is a breach، خلاص ما مش هيدوروا في الانتايتلمنت تاني. و binding but not final enforcement reserved until merits resolved by a word، إلا لو حصل له قرار تاني، يعني لو كان قرار interim not final. المطلوب احنا اتفقنا ايه؟ comply now argue later، في payment وفي amount طلعت determination للانجينير، سواء ارسلت ان او دي او ما ارسلتش ان او دي، فالانجينير determination is binding you need to comply، لازم تصرف. عايز تعترض ابعت ان او دي، ولما الداب دي بي او الاربيتريتورز يدوك قرار تاني يبقى القرار ده يتغير. بس اي قرار determination من الانجينير او decision من الداب formal decision they are both are binding، ما لم يلغى بقرار اعلى منه لازم البارتي يمتثل comply and then argue. عدم non compliance بيدي الطرف اللي هو المتضرر ان هو الحق ان هو يريفير الماتر directly to arbitration. تمام. طيب لو if parties ما اتفقوش، ما وقعوش عقد مع الداب، ما كانش في داب in place applies if disputes arise and dab is not in place. البوتوم لاين مش هنروح نشكل الداب، لا. اللي هيحصل ان هيبقى في الحاله دي المالتي تير هيفقدوا طبقه اللي هي طبقه الداب، وهنطلع مباشره للاربيتريشن. اوكي، so dispute referred directly to arbitration. الفيزيك ما بيقولش روح ايه شكل الداب وروح للداب وخد ديسيجن من الداب، لا، بيقول انت you can go directly to arbitration. why؟ لان مش معقوله قبل الخلاف يعني they fail to establish it so after it خلاص forget it. تمام. من كده بنكون اتكلمنا او خلصنا الجزء الخاص بالديسبيوت، واتمنى لو في اي اسئله او اي حاجه ممكن نتناقش فيها في الوقت المتبقي من الليكشر. فهنسمع كده الاسئله ونتناقش مع حضراتكم.
I notice a good point here to avoid loop when sending dispute directly to arbitration, for example, 21.8 or even 21.6, avoiding referring back to 21.4 again or 21.5. This, I think, gives two parties the value of time and avoiding inserting into a loop.
بالظبط، يعني بدل ما الاطراف يقعدوا يلفوا حوالين نفسهم وندور على لان لو في بارتي عايز يماطل ومش عايز يكون الداب هيدنوا في نفس يعني same attitude. If we are reluctant to agree on a DAB or members or whatever. بس وعشان كده in such a case الاربتريتور لما بيراجعوا الهيستوري ويشوفوا والله الداب ما اتشكلتش لان المقاول كان بيراوغ او بيعمل حركات وكده، فدي ممكن زي take in consideration when they decide the fees. مصاريف التحكيم مثلا ممكن يقولوا والله البارتي اللي هو كان متعنت في تشكيل الداب ده نحمله اكتر وهكذا. تمام، فبرضو الفيزيك بيحاول ان هو يطلع بره ان الامور تستك، وفي نفس الوقت الاربتريتور may consider البارتي اللي هو ما كانش متعاون ده في ان هو يتحمل اتعاب للاربتريتور يعني. So yeah, I agree with you on this. طيب other questions gentlemen?
The DAB may access to the site in regular time.
they have to. لازم كده كل فترة يكون ليهم زيارة للموقع حسب الاجريمنت وحسب الاتفاق. فاظن يعني ايه في ديدلاين كده كل كام اسبوع لازم مش متذكره دلوقتي، بس they need to have to visit the site from time to time.
Yes, شكرا.
Here, I think it is clear the importance of managing DC document control and management information system because documenting issues, disputes, claims, and focusing on time. Each section here refer to a period, a specific period, 28 days, 42 days, and like this. So, especially for the contractor, because contractors may pay attention for site progress and like this and forget to well manage the document or the information of the project. So maybe he is going to lose some rights when mismanaging documents.
Exactly, and this is what we call time barred. اللي هو لو عدى مثلا ما بعتش within 28 يوم، ما بعتش انه دي within انه دي within 28 يوم مثلا for example، او النوتس على ايفنت حصل. فطبعا this is why contemporary record او النوتسز او managing the time is very essential. Otherwise any party can easily lose his right and the matter become final and binding. So totally agree with you that contemporary record managing time and even يعني في بعض العقود حتى بيذكروا ان انت المفروض تبعت النوتس دي وعشان 28 يوم دول مهمين، ولو انت ارسلتها يوم 29 you will lose your right. يقول لك مثلا ايه احنا بنستخدم الاكونكس ده هو الميديوم في الكوميونيكيشن، ومثلا اخر ميعاد يعتبر نفس اليوم. لو انت مثلا ابعت up to مثلا 5 PM او 6 PM، بعد 5 او 6 PM يكونسيدر مثلا من اليوم التالي، وهكذا نظرا لأهمية التايم بار. يعني في بعض المشاريع بيبقى فيه very specific details النوتس تتبعت ازاي والمين ومن مين وايه التايمينج وهكذا. تمام.
شكرا
any
جزيلا. شكرا
الله
جزيلا.
يخليك يا باشمهندس. any other questions gentlemen?
I remember that in 999 the difference between 2017 and 999 about the NOD.
لا هي نفس 28 يوم يعني، يمكن لانه دي الحاجه الوحيده اللي ثابته في الاثنين، انما الميكانيزم بتاع مثلا الافويدنس واللي هي النون بايندينج ادفايس هي اللي مختلفه. طبعا في اختلافات، احنا وي كان سي ذات ان التفاصيل في 2017 او 2017 سوري في زياده حوالي 70% في التفاصيل يعني، ففور شور there is difference.
No, I mean in 2017 if you don't make NOD it's
time bar you mean?
but time bar about the time bar.
No.
But
No.
in 999 no, we can make another thing. after the time
يعني
bar ends.
مش كل العقود، السيلفر غير اليلو غير الريد، وفي بعض الكلوزز فيها تايم بار برضو يعني، وكانت جنرالايز يعني فيها تفاصيل برضو. تمام، يعني في تايم
بس
بار واضح في 99 برضو يعني.
there are the time bar, but after the time bar he can do another escalation. Here in
Yes.
2017 no, there's no
Yes.
escalation. After time bar no escalation, it's a binding. But in 999 no, you can make another escalation.
But again depending on the book type، مش كل الثلاث كتب زي بعض يعني.
I talk about it.
اوكي.
Right or wrong?
يعني محتاجين نرجع للكلوز يعني we can take it in general. Okay, so but I believe in principle لا، الاثنين once you missed NOD خلاص it's final and binding in both. This is what I remember and we can refer to it. Okay.
Okay, thank you.
Most welcome. So يعني I prefer this discussion is important when we are talking about claims and disputes. So it's good that we have time for discussion and for interaction with each other. So please feel free to ask whatsoever questions. There is no any silly question. All the questions are يعني good. There is no bad question. So feel free if you have anything to ask before we finish today's session. We still have.
Is there any time bar for non-compliance regarding to engineer determination or DAB decision to consider either party يعني fail to.
طيب هو الديترمينيشن والديسيجن المفروض ان هي بتبقى immediate compliance. يعني لو الانجينير عمل determination ان المقاول يستحق مثلا 300,000 بناء على كليم معين، اوكي، وخلاص احنا في كمان اسبوع في payment هتتصرف، فهي need to certify this amount in the payment. لو الامبلوير حتى even هو عمل NOD he need to comply، لازم يصرف. لو ما صرفش ده non compliance، دي مشكلة. This is a cardinal breach. Okay, so the compliance is immediate. امتى ياخد الفلوس دي؟ والله لو عمل انه دي وجات بعد كده الداب قالت له لا والله انت 300,000 دول مش من حق المقاول ويسترجعوا، فبالحالة دي الحالة دي المقاول يسترجع. انما اي decision اي determination is binding even after sending NOD unless it is يعني changed by or amended by a higher decision، سواء من الاربيتريشن او من الداب لو كان determination الانجينير. فالcompliance is immediate.
Okay.
تمام باشمهندسين. any other last question before we say goodbye? Yes,
In
please.
case of continuous event, if the determination is if the contractor send NOD for the determination, the DAP can be discuss the matter or still waiting till the end of event.
طيب انت بتتكلم على claim event continued.
مظبوط
طيب هو اصلا الديترمينيشن مش هيحصل الا لما الايفنت يتوقف ويتقدم لنا الفاينل بارتيكولرز. فاصلا يعني until ان الايفنت يعني as the event is continuing what is required from the contractor is a monthly submission of updates. This month we can see that our entitlement is we need this amount, we incurred this cost, and we need this number of days as extension of time and so on until the event is stopped, then it is referred to the engineer.
الريجكشن بتاع الانجينير على النوتيفيكيشن ما يعتبرش فاينل ديترمينيشن.
النوتيفيكيشن ما فيهاش ريجكشن. هي النوتيفيكيشن بيتقال عليها ان هي يعني send in a time يعني timeliness of the notification. يعني النوتيفيكيشن ما فيهاش entitlement. احنا بنقول بس يا ترى النوتيفيكيشن اتبعتت في الوقت المظبوط اللي هي within ال 28 يوم ولا لا. انما انا كانجينير ما فيش حاجه اسمها ان انا اقول ايه ريجكشن للنوتيفيكيشن. السنه النوتيفيكيشن تمام. الريجكشن او الابروفال او الديترميشن بيجي على البارتيكولرز اللي هو بيقدمها. تمام. انما النوتيفيكيشن ده هو بيعلمني ان في ايفنت حصل. انا كل اللي عندي يا ترى هو بعتها فعلا in a timely manner التايملينس بتاع النوتيفيكيشن دي، بعتها فعلا within 28 يوم ولا اتاخر وبعتها لي بعد 30 40 50. تمام. فلو الانجينير سكت بعد
تمام.
ما النوتس راحت له، معناها it is sent on a timely manner. يعني timeless. تمام.
مم.
لو اعترض مع 14 يوم نقول له لا والله انت كنت فين من 40 يوم ولا 50 يوم. انما النوتس نفسها يعترض عليها، لا دي ما فيش كلام من ده كده. في في المشاريع يقول لك ايه، ان اول بعت نوتس ابعت رد عليه وقول له وانت غلطان مش عارف فين وهاجمه في ايه، ده عشان بس ايه، احنا بنقفل كتاب بكتاب او خطاب بخطاب او لتر بلتر. ده البراكتس. انما لا، ده هو this is an obligation as a duty of warning، ان احنا كemployer when there is a risk the contractor is giving us a notice. ده الهدف اصلا من التايم بار، ان الواحد ما يبقاش مخبي حاجه. ممكن لو كان من اول الاذر بارتي اوير بيها كان عمل اكشن يعني يفيده. تمام. انما النوتس نفسها في حد ذاتها اللي هو بيتعمل عليها التست it is sent on a time يعني timely manner or اتاخر فيها. انت بقى تقول والله احنا we are rejecting or لما يقدم لك particulars. انما لما يبعت لك كده كلام وهمي، انا والله جالي دروينج والدروينج دي فيها اختلافات واي اف سي نيو واحنا هندرس وهنعمل وهنطلع وممكن يبقى في اختلافات وممكن يبقى في ابورتيف ورك وممكن يبقى في تاخير وممكن ماشي يا عم، الله الله معك يعني. امتى ارد عليه؟ لما يبعت لي البارتيكولرز. لانه لو ما كانش بعت لي النوتيفيكيشن دي كنت هقول والله انت الدرونج دي جات لك من شهر 9، انت جاي النهارده في اخر 11 بتبعت لي نوتس، لا انت كده عدى عليك بس. فهو بيحفظ حقه ان هو بيبعت نوتيفيكيشن. النوتيفيكيشن بقى هو لا قال لي محتاج كام يوم ولا محتاج كام وقت ولا اي حاجه. انما طبعا دايما البراكتس ان احنا ايه، لا رد عليه وقول له انت متاخر، او انت شوف الحته الفاضيه دي هناك كان المفروض تشتغل فيها ولا اللي هو الايه الكلام اللي بيحصل في المشاريع يعني. ده ملوش علاقه
مم.
بالفيديك يعني. تمام.
ومش considered rejection، يعني ما بيعتبرش ان ده rejected وما
اصل
ينفعش
دي
ريفير لي
دي نوتس دي نوتس.
determination.
دي نوتس، ده اشعار لا طلب فيه فلوس ولا طلب حاجه. بس هو الناس بتقلق الكلاينت والناس، انا جايب بي ام سي ليه ولا جايب استشاري ليه؟ ليه المقاول يبعت اصلا اشعار اديله على دماغه ورد عليه هكذا يعني. ده المينتاليتي. انما اتيز نوتس اشعار ما فيهوش اي ريكويست ولا كليم ولا انتايتلمنت ولا اي شيء. انا اقول لك والله احتمال انا بحفظ حقي. كم نوتس بقى بتتحول الى بارتيكولارز بتتحول لكليم؟ لو ممكن ما يبعت لك 300 نوتس في الاخر هم 5 كليم مثلا 6 كليم اللي قدم لك يوم عليهم بارتيكولارز. بس هو اي حاجه بس ايه، تعالى نعكنن على الاستشاري نروح بعت لهم ايه 3 4 خطوات على الصبح كده عايزين النهارده عايزين ننكد على دار الهندسه ابعت لهم 3 نوتس. الكونتراكت مانجر بتاع المقاول شدت حلو مش لاقي اي حاجه وهو متاخر ومش عارف يجيب بوند وعنده مشاكل في السيفتي والبروجرس والكواليتي، بس هو ايه عايز يصب على الاستشاري باي خطاب. واللي يجي الكلاينت يروح منكد على الاستشاري يقول له ما ردتش ليه على النوتس؟ يا عم النوتس ما بتردش عليها اصلا. بس
uh, but the engineer have the authority to reduce the amount, and the employer is obligated to pay this amount, just only this amount. This okay?
هو مين اللي عمل الترمينيشن اصلا عشان يريديوس؟ اللي عمل الترمينيشن الانجينير صح؟ لو قال مثلا الراجل ده يستحق 300,000، تمام ولا ايه السؤال بالظبط؟
صح، ايه انا قصد كده
تمام.
يعني.
طب خلاص انا هعمله في السيرتيفيكيشن 300,000. واي شود اي ريديوس؟ ما احنا اتفقنا الانجينير في القصص دي بيبقى نيوترال وامبارشال يعني.
ما ممكن ننقص، يمكن هو في وجهة نظره يعني يستحق اقل، قصدي يعني.
طب وانت انت ليه عملت له ديترميشن ب 300 اللي هو يستحق اقل يعني؟ لو انت الانجينير ولا بتتكلم على الامبلوير؟
لا، انا بتكلم عن عن اللي جاي من المقاول، يعني هو رافع طلب بانه يستحق 300، الانجينير
ماشي.
لا بيقول لا يستحق اقل.
ما هو ده اللي انا بحكي عليه. هو ممكن يكون ال 300 دول كان المقاول طالب 2 مليون مثلا، فالانجينير لما عمل الديترمينيشن لقاهم 300،
إيه صح.
فطلع الديترمينيشن ب 300، فهيسيرتيفاي 300، فالامبلوير يدفع 300. عمل انه دي ماشي على راسنا، بس لما يطلع له قرار بعكس ال 300 يبقى يعمل ده المقصود بالكومبلاينس. تمام.
والباقي يكون ديسبيوت، الفرق ده هو اللي يمشي بعد.
مش شرط والله، ممكن يكون المقاول كان بيهرج يعني وحب ان هو يبعت رقم كبير اكزاجريتد. لو ما بعتش ان او دي وعمل ريفيرال ما بقتش ديسبيوت خلاص، وهو كده فرحان بال 300 زي الفل بالنسبه له خلاص. ما فيش ديسبيوت، خلص الموضوع. لو عدى 28 يوم وما اعترضش خلاص بقت بايندنج بقى، ما يجيش يعترض على ال 300 دول بعد كده.
ما كده ما.
تمام. يعني انا شايف ان الاسئله برضو الحمد لله بتثبت المعلومه على الفيزيك اكتر، وخاصه ان احنا يعني unfortunately في العقود بتاعتنا ما بنستخدمش طبعا الايه الريسنت او المودرن ستاندرد، بس كويس ان احنا في الاسئله دي ونربطها باللي احنا بنستخدمه، تثبت ان شاء الله المعلومه، ويبقى برضو على اتليست احنا بنعمل بنش ماركينج وير وي ار من البيست براكتس يعني. تمام. any other questions gentlemen؟ طيب
في سؤال معلش بس،
اتفضل. لا مش معلش، بالعكس
إذا
اتفضل.
إذا المهندس طلع determination ومضت
Yes.
28 يوم وما في طرف عمل هنا ودي، لكن ليتر اون الانجينير نفسه حس انه الديترمينيشن اللي عمله وبقى فاينل وبايندينج، فهو ايثيكالي كده حس انه في شيء والديترمينيشن تبعه ما كان صحيح، فكيف يعمل في الوضع في الحال؟
لا هي ما فيش حس يعني، هي لو قصة، لو كان مثلا في بعض الأحيان لو كان في مثلا فرود أو ميس كوندكت أو يعني حاجة زي كده، ممكن يرجع فيها إن هو الحاجات دي ما بتنتهيش، ملهاش ديدلاين. إنما هو عمل ديترمينيشن إن وهو نيوترال وهو يعني كذا، unless لو في بقى يعني مثلا ممكن تبقى arithmetical error، وهو جاي بيجمع 2 زائد 3 عملها 7 مثلا او شيء، فهو ممكن يعمل تصحيح، يطلع النوتس بالتصحيح. انما بعد ما درس وعمل انتايتلمنت يجي بعدها بشهرين 3 يقول والله لا ده انا حاسس ان انا غلطت في الكلام ده، لا ده مش مكتوب في الفيديك يعني. انما لو حصل مثلا تايبو، كتب كلمه غلط، عمل اريثماتيكال ايرور، جمع تجميع غلط، فهو بعدها ممكن تلحق يعني ب ب ب ب يعني بنوتس وبامندمنت معين، بحيث ان هو ايه بيبقى ده الحق للديترميشن بتاعه. انما وانس ان هو عمل
المقاول نفسه ما حيسيب حقه، المقاول نفسه حيلحق الموضوع، لأنه
بالظبط.
المقاول ما
لو
حيسيب حقه أبدا.
لو في تايبو وفي ارثماتيكال ايرور. انما لو هو قرار لا خلاص اتدرس وطلع ديترمينيشن، مفيش حاجه اسمها يحس بعد كده ان هو يعني غلطان، لا. الا بقى اكتشف ان كان في فرود، كان في نصب، كان في دوكيمنت مزوره، دي قصص تانية بقى، ختم مضروب بتاع كده يعني. تمام. طيب
شكرا
any
جزيلا.
other questions؟ طيب تمام، سعدنا بيكم وان شاء الله نراكم على خير الاسبوع القادم. السلام عليكم ورحمه الله وبركاته.
عليكم السلام ورحمة الله وبركاته.
وعليكم السلام ورحمة الله.
عليكم السلام ورحمة الله وبركاته.
السلام.